Welcome back to the Law of Attraction. I'm Stephanie Haney, and today I'm here with Richard Vaughn, founding partner of the International Fertility Law Group. Thank you for being with us today, Richard.
Thank you for having me.
Now, today we're going to be delving into some of the more complicated issues in fertility law, specifically what happens to embryos when the people that create them disagree over what to do with them. But first, let's get started with sort of what got you into this sort of niche area, Richard. How did you end up practicing specifically fertility law?
Sure. Well, I actually have kids through surrogacy and egg donation. And as I started entering into that process, we had to speak with a lawyer about the contracts we would be entering into, the court process we would be going through. And in talking to that attorney, I found myself really fascinated about the process. And I called the guy back a couple weeks later. I said, "What's it like?" And it happened to be right time, right place. And I started working with him.
So what is a typical day like at International Fertility Law Group? I know there's probably no typical day,
Yeah.
But what kind of cases come through your door?
Well, we typically work with intended parents and consult with them and get them started on the process when they first need a contract with a surrogate or might need a contract with an egg donor. Sometimes we work with egg donors and surrogates directly. So most of our business comes from agencies. Agencies help match intended parents with prospective surrogates and donors, and then they send the clients to us to help them with the legal work. So a lot of my time is spent on the phone with the clients or Skype calls with clients from all over the world because they're coming here to the U.S. because surrogacy is illegal in most places of the world.
Now, working specifically in the intended parent domain, it seems like the laws surrounding fertility law are pretty unsettled. I mean, how would you describe the fertility law climate?
I would agree with your categorization that the law is fairly unsettled. It's been going on for about 30 years, in the U.S. at least, and that's still kind of a new area of law. Many states do not have legislation. Many states do not have case law that will help guide you in how to handle these cases. So a lot of what's happened over the last 30 years has evolved out of custom and practice. Things that the lawyers and the judges kind of working collaboratively together have figured out about how to handle these cases, how to establish parental rights, and to keep those parental rights secure.
Now, when we're talking about securing parental rights, do you get any families coming in that want counsel regarding their consent forms when they're going through IVF and they're maybe freezing embryos?
We do from time to time get clients that ask us about medical consent forms. Those are primarily medical in nature, so for the most part we don't review those. So we might refer them to someone else who can review the medical consent forms. These consent forms should be explaining the procedures that they're undertaking, the medications that will be undertaken, and the risks of those, the benefits of those, and the alternatives, and then they sign a consent form saying to the doctor, "Yes, I'm ready to go forward." The one thing about those consent forms that crosses over to the law is that they often have disposition statements in them about what to do with any remaining frozen embryos.
Speaking of the disposition statements, that brings us to the case of Mimi Lee and Stephen Findley, which was recently settled in Northern California. And this decision just came down in November, where they upheld the consent form as a binding contract between Ms. Lee and Mr. Findley,
Right.
and forced the embryos to be destroyed. What do you think about that?
This kind of all goes back to the first case reported in this area, which is the Davis versus Davis case out of Tennessee from 1990. And in that case, the court decided between divorcing parents who had frozen embryos left over, and the mother wanted to use the embryos to procreate again, and the father did not. And they ultimately decided to weigh the right to procreate against the right not to procreate, and decided on behalf of the right not to procreate. In essence, this issue can get really complicated when you look at the various consent forms or the contracts, and whether you view the consent forms as advance directives, or if you view them as binding contracts, or if you're trying to weigh the right to procreate against the right not to procreate, or perhaps in some of the recent cases, which essentially let the mother use the embryos against the wishes of the father because she had some sort of fertility issue, some cancer or something that prevented her from procreating on her own naturally if she weren't able to use these embryos. So all of these things get balanced in the analysis. And for me, I think it can be simplified back to, if you look at assisted reproduction as an extension of procreation, in assisted reproduction you are creating a child. You might need some assistance medically to do it, or you might need assistance from a donor or from a surrogate to do this, but you are creating a child. So in essence, it is an extension of procreation. If we were procreating, it would be a joint decision. If we sat down and we had a debate over whether to have a child, and I didn't want to, then there would be no child. So I still think the Davis versus Davis case from 1990 is the direction that these cases should be going. But the courts are struggling with, how to reconcile all of those competing issues.
That brings us to the case that's happening in our own backyard here in Santa Monica, California, Sofia Vergara and Nick Loeb. Do you have any comments on that?
That's a combination of two different issues. One is the use of embryos, but also his rights as a sperm provider and what their intentions were when the sperm was provided. There are a number of sperm donation cases that are being litigated across the country as well, where there's some sort of blurring of the lines between the role of father versus the role of sperm donor. So again, I think the issue still comes down to the right to procreate versus not to procreate, and I think that's the last ruling that was issued. She didn't want to procreate, so the ruling was in her favor.
Now it seems to me, and this may be an oversimplification of things, but if we sort of change the way we think about things from the very beginning, we might not have these problems. Like we could be counseling women to freeze their own eggs, and we could be counseling men to freeze their own sperm, and maybe to freeze some embryos too at the same time. Is that a trend that you're seeing?
I wouldn't say that it's a trend that I'm seeing, but I do see it as a viable alternative and a viable solution to the problem. If people are freezing their own individual genetic material and not combining it yet, they then still have ultimate control over what happens to their individual genetic material. So I do think that could solve the problem. You have some issues there that you'd have to overcome with regard to convincing people, usually younger in life, to do something that they think is probably not necessary. They've got plenty of time to have kids, etc. But I do think that's one solution to the problem. Perhaps it's something that could be recommended to parents going through assisted reproduction before they make those embryos. One of the other issues is more medical in nature, in that egg freezing is not as successful as freezing and then thawing sperm. It's getting much better, improved dramatically in the last 10 years for egg freezing, so that does make it a viable alternative. But in addition to that, I think something that as lawyers we should be recommending that these parents do is consider a separate written contract between them about what to do with remaining embryos. Because if the medical consent forms at the clinic are going to be viewed more as an advance directive, such as a will or a guardianship statement that you can revise or revoke at any time, that doesn't give anyone much to lean on in terms of what do we do in the future if there's a dispute. So rather than rely on those, have a written contract between the parties that explains what they want done, and then enforce that.
All right, well, thank you very much for your time today, Richard. That's all the time we have today. Thanks for watching The Law of Attraction. This is Stephanie Haney.